but we will proceed. So I'm going to call this meeting to order, the Thursday, August 20th meeting of the Community and Economic Development Committee. And if we have the availability to call roll, Mandy, I think that'd be the best way to get us started. Thank you.
Yep. And I was emailing with Mr. Weddleton for some handouts, so those were just sent out, so I know he will be on shortly. I don't see him on right now either.
Okay, great.
So, Mr. Weddleton? Ms. Kennedy?
Here.
Mr. Peterson?
Present.
Mr. Constant? Mr. Dunbar?
Here.
Ms. Zalatel?
Here.
Ms. Quinn Davidson?
Here.
Chair, you have a quorum. For non-committee members, Mr. Rivera? Mr. Perez-Verdia? Ms. Allard?
Here.
Ms. LaFrance? Okay, thank you.
Great, thank you, Mandy. Okay, and I'm sure I know that we have several staff administration folks on with us as well. And I think what I'll do is rather than going through and letting everyone chime in that they're here, if there's an opportunity that you want to speak, please just introduce yourself, and we'll use the queue as much as possible. And if you need to interrupt otherwise, please do. We'll get through this. So I just wanted to ask the assembly members right now if there was anything that needed to go onto our agenda. It looks like a relatively small agenda, but I'm sure once we get started talking about the updates to the marijuana licensing process, there may be more things to add there, and that could go on for a while. But anyway, is there anyone that wanted to add anything to the agenda? And that can be staff too, if we missed something that needs to be talked about today. All right, well, I am not hearing anybody wanting to add to the agenda, so we'll go with our the new business and the ongoing business items, and we'll start with new business. So we have a marijuana application for expansion on a manufacturing. So anyway, if you can start us off with that, Ms. Honest, I think we can probably begin here. So.
For the modifications for the special land use permits, it doesn't affect the license. So the clerk's office review deemed it okay according to what the license is. So Ryan or one of the planning staff will talk about the modification itself.
Okay, great. Thank you. So then, yes, Ryan, we'll turn it over to you, Mr. Yell.
All right. Thank you, Madam Chair, and good morning, everyone. So this is a request for a modification to a special land use permit for a marijuana cultivation facility. They'd like to expand the licensed premises area into an adjoining unit. The current facility occupies Unit D, and they're proposing to expand into Unit J. Both units are approximately the same size, right around 969 square feet. So expanding into an adjoining unit is a 100% increase. The existing facility was previously operating under the doing business as AK Joint business name, and that was approved by the Assembly on November 7th, 2017 via Assembly Resolution 2017-354. The petition site is located southeast of the intersection of King Street and East 77th Avenue, and Voodoo Cannabis Company is the new DBA. And they're going to be operating this business in conjunction with a co-located marijuana retail sales establishment under the business name of AK Joint. On July 1st of this year, the Planning Department did mail out 153 public hearing notices for this case, and as of this writing, no public comments have been received. We've also sent a public hearing notice to Taku Campbell Community Council, who did not submit any written comments for this case either. It's important to note that the site does have non-conforming rights for the lack of site perimeter landscaping as well as a building encroachment that's present on the north side of the lot. Those non-conforming rights will not be affected by this modification. And we do feel that this modification maintains compatibility with the surrounding area. And the planning department does recommend approval of the special land use permit with the one condition as stated in the staff report. So with that, I'd be happy to take any questions. Thank you.
Okay, thank you, Mr. Yell. We have been joined by Mr. Weddleton, and Mr. Weddleton has the first question.
Hi, thanks. A couple things. Is there a representative for the company in the meeting?
Yes, I'm here. Colleen Howard.
Yes, it looks like, yes.
Colleen
Yes.
Howard. Okay, good.
How-
I have just a little questions just going through the packet. One is you know, kind of the write-up is Voodoo Cannabis. Oh, and I want to clarify too, it's cultivation, not manufacturing.
That's right.
I don't know if this is critical, but it's DBA Voodoo Cannabis, and I guess that's the cultivation. And then it says in the title AK Joint, but in your advertising, it seems like you call it Joint Ventures. You had a flyer for a meeting. It's on page 11 and 96. So kind of, I mean, so the applicant, do you go by Joint Ventures? Is that?
Alaska
you-
Joint
is it
Ventures is the LLC that owns both AK Joint and Voodoo Cannabis Company.
Okay, so with the public, when they go, what do they see? If they, or probably the public doesn't go, but say other companies, do they see Voodoo Cannabis on the door, or is it AK Joint, or is it Joint Ventures?
Okay, so are we talking about the retail or are we talking about the cultivation?
Well, if you could clarify on all of them, just so I know.
Okay. All right, so the retail does business as AK Joint and the sign above the door says AK Joint. The
Okay.
cultivation does business as Voodoo Cannabis Company, and there's no external advertising for Voodoo Cannabis Company.
Okay. Okay, I just want to make sure that it looked a little inconsistent in the write-up, and I just want to make sure it's all clear. I think that's fine. So one thing I noticed, the police reports at the end is I think for the whole complex there, not just your units. But there were a lot for welfare checks. There was a robbery on February of this year, several for noise in August of last year, theft in June of last year, burglary June of 18. Is that your business? Are you guys having trouble there?
No, it's quite a few of you listed, and no, we haven't had any noise complaints that I'm aware of. There's 16 units here, so I can't attest for anybody else besides mine. We did have an attempted robbery. I think it was in February. It was a failed attempt basically, and they left, and we didn't engage in with anyone. We called the police, as you can see. But other than that, none of those are related to my business.
Okay. So tell me about the robbery. Was that like during open hours, someone came in and tried to steal stuff, or? Wow. Well, that's not good. Was that your,
No.
I'm sorry, your retail or the
That was
cultivation?
at the retail, yes. This is not the cultivation. This is at the retail.
Okay. Well, sorry that happened. Glad you
Yeah.
thwarted it. So then I have one other question, and it strays a bit from the license, so doesn't really impact this decision, I think. But it was something I learned. I did a tour with someone from an outreach worker to homeless a few days ago, and I noticed that a number of the people we met had like a gallon Ziploc baggie with this crumpled plant in it, and I thought it might be cheap tobacco. And but the guy I was with said no. What they do is they'll go to the dumpsters where marijuana shops are throwing out their the leftovers, the stems and stuff that are ground up and it's supposed to be mixed with other stuff, so they're 50% or so it's diluted. But they will gather that up, go to the dumpsters, and they say if they smoke enough of it, they'll get high. And that was totally new to me. Are you aware of any of that?
So that sounds like a bit of an urban myth. I can't speak to any other operation other than our own, But any marijuana waste that we have, obviously, we follow the rules. We mix it with something that's unsmokable. But in our case, what we either drive it directly to the transfer station ourselves, or in the case that we can't do that, our dumpster is basically it's a modified bear-proof dumpster. There's no getting into it. Once it's secured, there's no getting into it. It's always secured. But
So is the urban myth that, oh, sorry, go
I
ahead.
don't believe that anybody's going to anybody's dumpster and pulling out gallon bags of discarded product. No, I don't think that's true at all.
Yeah, okay. It seemed odd to me. Would it be possible to even get high off of the stuff that's in there?
Well, it all depends on what they're throwing away. But why would I, as a producer of product, throw anything away that's usable? That all can be sent to manufacturing. If it's poor enough quality that you wouldn't actually want to smoke it because maybe it was too harsh, you would then just send it to manufacturer and get a profit that way. There would be no reason to throw away anything that's usable.
Okay, well, it's good to know. Thank you. I'm done. Thanks, Crystal.
All right, thank you, Mr. Weddleton. We have one more question for you, Ms. Howard, or maybe for somebody else, but anyway, stay on the line, please. We have a question from Mr. Peterson.
Thank you, Madam Chair. And so this was originally a limited grow, and so now you're moving up to an unlimited grow and expanding to the area next door. Am I reading that correctly?
So yes, we were a limited cultivation, so less than 500 square feet under canopy, and we are expanding into the unit directly behind our unit. It's a front back type situation.
And there's, if I remember correctly, there's already a door that connects between the two units. Is that correct?
This whole building was kind of set up for like retail space in the front and warehouse space in the back with a connecting door. That's correct.
I see. Okay, and so how many additional feet of cultivation are you planning to create?
Only about 600.
About 600?
Yeah,
Okay.
It's just one room. Yeah.
All right, thank you.
All right, thank you, Mr. Peterson. And thank you, Ms. Howard. And yes, I stand corrected. Mr. Weddleton is corrected. This is a cultivation license and expansion, not manufacturing. So looks like we have Mr. Yale back in the queue. So Mr. Yale, go ahead.
Yes, thank you, Madam Chair. I just wanted to clarify that the municipality does not differentiate between limited and standard grow licenses or special use permits for marijuana. That is something that the state has taken. They do differentiate between limited and standard, but for simplicity's sake, the municipality, it's just all one cultivation license and special land use permit. So thank you, that was all.
Great, thank you. I don't see anybody else in the queue, but are there any other questions? And I don't see anyone responding there. So Ms. Howard, I was just going to give you the last word on this. If you had anything else you wanted to add or tell us about.
Nope, that is it.
Great. Okay, appreciate that. Thank you. So what is the will of the committee on this application for expansion on the cultivation for Voodoo Cannabis
Weddleton
Company?
moves to improve.
Second.
Okay. And there's a second. So is there any opposition? All right, hearing none, then this committee will go forward with a recommendation. I believe this is on our agenda for this coming Tuesday. So Ms. Howard, just so you know, the committee will basically provide a recommendation, but the entire assembly will be voting on this. So it might be a good idea to be there on Tuesday night, just in case there are additional questions.
Sure.
So, thank you.
You bet. Thank you.
Okay, then if there's no further business on this particular item, we will move forward then on talking about the updates, the various updates to marijuana licensing process. So I'm not sure who wants to kick this off. I know we have a bit of a running list that we've started to gather some ideas on how to move forward on this and the things that we need to do. There are some state updates that have happened that we want to kind of correlate with our own code. So I don't know if that would be a good place to start on that or not. So I don't know, John, if you have anything you want to say to actually start this off, or if Mandy wants to start with looking at maybe where we're at with trying to mesh the updates with the state codes.
Yeah, if I could chime in a little. I think that would be good if have Mandy go through if there's any updates we need to do. And then I had asked Mandy to send around a document that was just, I think the last time we looked at this, we looked in January, had on for 2 meetings, and then we didn't really address it, that I saw after that was on the agenda a couple times. So I asked Mandy to just send out again a document that kind of recapped what we had in January. And then also there's a kind of a draft AO that Dean had put together, and that went out in May, and I'm not sure we ever addressed that, but again, my notes might be incomplete. So that's something, if Dean's available, maybe just kind of to go through that. And I think what it really is it's just kind of a template for us to fill in, you know, places we might want changes, and there are a few changes kind of in there. So, but I don't really remember the status of that. So if Dean is with us, maybe he could go through that. So Mandy, did you send around that Word doc that has that draft AO?
I did. I emailed it out, and I also posted it on the CEDC webpage.
Okay, great.
Great.
Is Dean here?
Well, yes, we do have Mr. Gates with us.
Yes, I'm here.
Okay, so I'll let
Go
you
ahead,
go,
Mr. Gates.
Crystal. But
So you wanted me to walk through the AO document, is that correct?
well, we might start like Crystal
Yes.
said, and let Mandy talk about state changes, and then maybe go to Dean's document. So, but Crystal, I'll let you decide.
No, that's fine. Mandy, if you want to go through what you've got there and what you know about what the state's been doing, then we can be updated on that particular thing. So thanks.
Sure. So the AO that Dean has actually was kind of our start on incorporating the state changes. So recently, most of the changes that have gone on are in regards to the COVID emergency orders allowing for the curbside pickup and such. So that would not be something that would affect our code. So everything that was prior to is what we've been working on getting in that AO. And that was something that we had kind of gone over prior. So there's not really anything new that would affect us of the recent changes that have gone out. So everything should be working towards getting in that AO already.
Okay, great. Then maybe we should just let Mr. Gates go ahead and talk about the AO as it stands right now. So you want to do that, Mr. Gates? Thank you, Mandy.
I wouldn't say I'm ready, but I'm going to talk about it anyway. So see, yes, like Mandy said, if I understood right, that the state's regulation changes, they have their process for promulgating the regulations, and when they're making amendments to the existing ones, there's a document, and you sort of have to, it's a little laborious to find the right one, because they usually issue new regulations that are just clean and unmarked. Here's the new ones. And if you want to find the markup to see what's changed from current regs to what the proposed new ones are, you sort of have to dig through their website, which isn't really very user-friendly. And that's why I appreciated having an intern last spring who did most of this legwork. So I've got a thick stock of those documents from the state to make sure that we captured all of the changes precisely. And what she did is we put together this AO that has all the changes where we have a corresponding code language that matches the state regulations. And as I think we all know, there's a number of state regulations that we decided not to codify a similar provision. For example, the different types of cultivation licenses, limited and standard, as we heard about with Voodoo earlier. So if they have a change to that, it's not there, but our research sort of puts it all. So anyway, the AO document was put together, and unfortunately, I haven't really had time to work on it since. Well, we worked on it some in May. I did a little work since then, but it's been a little overwhelming to keep up with the COVID-19 things. And now that we have, I guess, some additional help in my office, I will try to dedicate some time to this. Anyways, so section 1 at the front, and yeah, that's just the standard to give it's sort of the key, the legend to what the sectionals does for someone unfamiliar with code revisions. And I went through and put this together to show that some of our provisions have no change, and I marked those, as you see in the second section 1 on line 31. Should I be sharing my screen here, perhaps?
If you can, sure. And members know that there are copies available, so I'm just kind of skimming through this right now. But go ahead, Mr.
I'm sorry, I missed that.
No, I was just commenting that I was just kind of flipping through all of this now, and there really doesn't look like there's much at all. One thing I did notice that there are some things that are underlined in yellow and some in red. So can you clarify what the distinction is?
Let me see. I kind of need to see what you're speaking of. Do you have a page number?
Oh, I skimmed down pretty far and I saw something that was highlighted in red. And then I've noticed that there are things that are highlighted with yellow. So it looks like the yellow might be places where there were things that were added in, and maybe red was places where things were being deleted. Is that fair?
Yes, I think so. Like here on page 17.
Yes. On page 17, there's the highlighted
I
red.
think,
Yes.
And I sort of need to look a little closer at what exactly, but I think that this was recommended for deletion because the assemblies is the licensing body, and if there's a revocation, the assembly would have already done it. So, and maybe it matches the state language, and there's no change to the state reg. So this is sort of, I think, and I could be wrong, but I think this is a change that we wanted to update our code for the municipalities' licensing administration operations. And it might be different at the state, but perhaps the state has their director revoking a license. But here we have only the assembly that can do a revocation. There's the clerk has the authority to suspend, for imminent safety concerns and things like that. But I don't think the revocation is available only by the assembly. So with B up here at the bottom of 15, the assembly finds that the license has been revoked. Well, that would have already been an assembly action. So it's a little it would never happen that the assembly finds it was revoked and therefore it denies the renewal, I guess. And I'm not really sure, actually. I need to look at that more. Maybe it means a prior revocation. So maybe we can find a different example of some red.
Okay, well, and I didn't mean to jump ahead, really. I just saw that really jumped out to me, and I'm sure these are all editing highlights. But if you want to start where you were starting, Mr. Gates, please go ahead.
Well, actually, this is a 81-page document. So I don't mind if people want to just jump in and ask a question about this page or that. That might be more efficient than if I went section by section. I mean, unless we have all day.
Yeah, we probably don't have all day.
So
that's a good
I
point.
was.
So,
Yes, so I think I explained sort of our process here, and part of it's updating the regs, part of it's we have our rolling list of issues that are specific to this municipality where we want to do some updates, and that's that other document, and we've incorporated some of those here. And see a lot of sections that have no change, they were included in this AO so that, you know, you, the committee, you have the full chapter 1080 for our licensing administration. Maybe you see a change needs to be made, add a section that the state regulation hasn't changed, and maybe the clerk, Mandy, and myself have identified a change, but some of you see a change needed. So I include that language just so it's in front of you with this, and we update, you know, a comprehensive update once that way. So let's see. I'm not quite sure what else I would want to jump to. I could go down to the main ones. I really don't have a list of specifics that I planned to highlight here. If anybody has questions through the document, I'm happy to jump to a page and try to talk about it.
okay, are members familiar enough with this to be able to look at a specific section that they might have questions on?
Yeah, I've got, I wouldn't say I'm familiar with. Can I jump in?
Yes, please.
Okay.
Mr. Webb.
So looking through it, it's I mean, this is a good thing to have. I'm curious about some of the things in here, because they don't necessarily match notes that I have, but looking at, say, page 26. Going back there. There's a new section D. Access restricted marijuana retail stores, titled, and D, if a retail marijuana store displays marijuana to a consumer for purpose of smelling the marijuana before purchase, the retail marijuana store shall package the marijuana in a sample jar that is protected by a plastic, metal, or protective mesh screen, and so on, which is interesting. Maybe that's useful. Where would that have come from? And it looks like Abby kind of went through these, so that looks like Abby's work.
And so
Dean,
page 20, I'm sorry.
26.
Oh. So one thing here, you see these yellow pieces, and you can see the pop-up 5/9/2019. That's the effective date of the state regulation change. So this is just to align the state regulation. And I think that's Abby's work in terms of duplicating the language from the state reg change. And if we wanted to be a little different or more restrictive than this, we could. And so that's for the committee's consideration. But if your notes say something different, and that's important because John, you take great notes. Is there something that we should do differently here?
No, I think that's what I needed, Dean, is what that came from. So I understand now. So and I guess Mandy had said that a number of the changes here were just to reflect state of Alaska changes. So that's or maybe all of the changes here. So okay, this is.
Yeah, this one with Abby's note saying the effective date was May, these ones would be ones that came from the state changes.
Yeah. So any point you see this little pop-up yellow balloon, and that means it's corresponding to a state regulation change.
Okay. Okay, so that's what we have here. So this is a good starting point for us then, for things that may need to be done. Okay, thanks, Crystal.
Okay, sure.
I think I'm done on.
And it seems like I'm sorry, John, go ahead. What was the comment?
I think I'm done.
If I may,
Points on.
Oh, got it. Okay, thank you.
well,
So,
I think
and
that
it may
really
well maybe,
what is helpful for me for drafting here, and like you said, this is a great starting point. We need to start with comprehensive sections put together, state regulations put together. And I think our next step to be efficient is we have that list of suggested changes, right? Whoops, where'd it go? Oh, it's here somewhere. And if we could talk about that and which ones the committee recommends or how, and those would be our own local updates for our code. We could include those in this ordinance. And that's where I think I need the most direction to go forward here is from the committee looking at that list of suggested changes or issues to address and giving guidance at which ones we should incorporate in this document. And then I could draft the language and bring it back.
well, there are some kind of big ticket items, what I would call big ticket items in some of our suggestions that on this list. And I think the very first one is probably the biggest one, the idea of limiting the number of licenses. And, we haven't even really begun to have that kind of depth of conversation on that, because I think that is going to be a very big conversation, particularly with the industry itself. Any comments on how we might move forward with this list?
Crystal, if I
I
may.
tend to think go ahead, John.
Maybe I think for starters, something like limiting the licenses is so big that should almost be a standalone ordinance. So I'd kind of to get things rolling on this, maybe go through this list, and some of these are kind of low hanging fruit, things that we've discussed, some things we've added as conditions anyway, and maybe get those, and then Dean could start adding those to the code. And then maybe, some of these really big ones, like, the limited number of licenses is a big deal. That if we put it in with 30 or 40 other issues that are fairly small, I think we clog up the discussion of that critical piece.
Right. That would be something that's better for even just having an entire work session on, because I think that will be a big deal. But I have Mrs. Olatel in the queue, and looking at one of her suggestions, that might be one we could tackle. But anyway, Meg, go ahead. You've got the floor.
Thanks. Someone's flipping papers. If they could mute, because all I'm hearing is flipping papers. Thanks. Yeah, I think if there are, I like to go through this list, and maybe we have a couple of work groups, frankly, on some of these, that then the work group could come back to the committee with kind of a path forward. So, because I agree that some of these are rather large and standalone versus more technical alterations to the code that bring it either in line with the state, like the limit of license and a few others. So that was my only thought, and I'd be happy to participate in one or maybe two of those. I just feel like with the CEDC committee, because there are a lot of other things that we we won't get through things very quickly if we only use this forum as a way to work through some of these larger items.
Great, thank you. Yes, I agree with that. And actually, we did have, at least for one or two meetings, a working group, and we really didn't get too far on that. And so I don't know if that process is really going to work well. And it was just maybe a timing thing. I mean, we pretty much got slammed with a lot of other things that the assembly had to deal with. So I think trying to have an additional meeting just got to be too tough on everyone's schedule. So we can certainly move forward with the idea of trying to do this through that working group, or like I think what you're saying, Meg, is maybe we have multiple working groups that maybe cut this list in half and we tackle different parts of it. So, Mr. Weddleton, any thoughts on that?
Yeah, you might hear my printer going in the background. I apologize. I think maybe a combination. I'd like to go through this list. Some of these things are pretty far along, and just check those and say, okay, Dean, please add this to that draft AO, and then see what is left over that's really big, and then maybe spin those off into other groups, or just, we could have another meeting, a CEDC meeting on it. So
Excuse me, I'm sorry. You said add which one to the AO?
I'm sorry, Dean, you want to repeat your question?
I'm John. I think you said add this particular one issue to the AO. Which one was it?
Oh, I'm looking at this. Okay, yeah, this document that's on the screen now.
Oh, yep.
There's one bullet starts with Meg 11-519, and it it's an important point that came up when we were dealing with the Hope Center and Alaska Sense. So this is something that we discussed. I think it's worth having in there for if it can, if they, I would put this in there and then draft AO, and we may not make it through the process or maybe change, but it's far enough along, I think, to plug it in there. So there's probably a number of things like that that we could get added into that AO right now.
Well, let's do that right now. Let's ask the committee if there's any objection to taking that segment there from the departmental review and adding that to the draft AO. Any comments on that? Or any? Oh, go ahead, Mr. Gates.
Actually, I need to add something here. This part is the Title 21 change, I believe. So this ordinance is Title 10, and for amending Title 21, I think that that's one decision to ask this committee now. As you know, text amendments to Title 21 normally go through the Planning and Zoning Commission. We have had, I think, fairly often waiving Planning and Zoning Commission review, and for a Title 21 ordinance related to marijuana, because the Assembly because Planning and Zoning isn't involved really in any part of reviewing special land use permits for marijuana. So that's sort of been justified, as opposed to some other proposals that waive Planning and Zoning Commission review and become been controversial topics. I don't think that's the case here. So if we want to do that, I think the committee should decide, do we want to separate a separate AO for Title 21 amendments recommended from this list and go through Planning and Zoning Commission review, or incorporate it here and waive Planning and Zoning Commission review, because this is limited just marijuana related Title 21 language.
Okay, thank you, Mr. Gates. That was good clarification, and you're correct. We need to make sure we keep the two chapters separate. So that might be the first thing to do, is to look at these from that perspective and maybe just identify which ones would be Chapter 10 and which would be Chapter 21. But we have Mr. Dunbar in the queue, so go ahead, Forrest.
Yeah, a little bit early. I just wanted to concur with what Mr. Weldon said about the limit on licenses being something separate, and that we can hopefully craft an ordinance or ordinances that address the other things first, and hopefully within this body. But I do think that the limit on the limit on licenses is going to be a very very big discussion, and heated and long term.
Yes, thank you, Mr. Dunbar. Yep, that is going to be a big one. Okay, so if we move forward with just trying to identify some of the things on our list that apply to the licensing and just Chapter 10, can we pull out which ones of those we think are going to apply? I think if I look at from the top of the list, it looks like the one that I suggested about how we have some kind of criteria that will trigger whether or not we pull a license for review by this committee when it's being just a renewal license. So I guess I would submit that one. And actually my aide has been working on putting that into more of a ordinance form, a resolution form for bringing it forward to the committee. But I could certainly, and I might have actually given that to you already, Mr. Gates, but maybe not this one. But anyway, thoughts on that? Is this one ready to go in some format to Mr. Gates for including in this particular AO?
In my view, I think that, yeah, this sort of direction is I think it fits in with this AO, is to include criteria in the decisions to pull a license for renewal review and so forth. I think that this is a good topic to include in the AO. I think a little further direction we needed is in the criteria, because that is something that's a policy making sort of issue. What sort of criteria should we have? And I guess I could propose some, but we need direction on what to include. So if we have some criteria already, we could email that to me individually if you wanted, what criteria you think is important, or discuss it in committee. But I think I'm more comfortable having assembly members tell me what criteria should be in there for polling, and maybe it's a specific and very objective, or maybe it's a subjective criteria that's a little vague. Doesn't matter, but we can start at least with some direction and get some language. And Crystal, I don't think I recall. You might have sent it to me, and I will look. I don't recall receiving more than what's here in this document from you on this.
Okay, thank you, Dean. And I do have about 5 or 6 criteria, just one of them being the number of violations, another one being police response. I think there was a request by community council, maybe even request by the owner. So I will actually just send that list off to you because I know I have it. So I will forward that to you. Okay. Is there anybody in the queue at this point? I don't see anybody right now. So what else on our list might be something that would work well in our update to chapter 10?
I think rolling down to that increase in fees.
Okay.
Are we ready?
Oh,
Move down
okay.
into
Yeah,
that next
the
one.
little bullet point. Okay.
And the issue there was,
Sorry.
if you have an NOV for odor, it's, X dollars or whatever when they finally decide to do fines. And apparently some people think it's just cheaper, just keep paying the fine instead of increasing it. And I think that one, maybe the best way to go would be to send it to Jack Frost and his team and say, okay, recommend something. Or is that, Dean, can you look at what is standard for escalating fees and start us there?
Well, yes, I can look into that. It's quite common actually to have some escalating fees, like a 100 first offense, $200 a second offense, or $250, $500 third and subsequent offenses. They usually watch it up like that. Our fines for violations are designed that way in Title 14. So I think we already have some. So if it would be helpful, I can pull out the sections that already have some graduated fine structure in which sections they correspond to. Actually, I can bring that to the next meeting if that's what you are asking.
Yes, that would be good.
Okay, great. Well, there's one there. It looks like we already talked about the next one on the list. And then the one after that is about who's checking for truthfulness on the checklists on AMCO forms. So that might just be a question, maybe not necessarily something to work on, but can we have a little discussion about that? And maybe that would be, obviously this could be a chapter 10 issue, but Mandy, do you want to comment on that question? Who does the checklists on AMCO? How do we know they're actually correct in all the?
So for the licensing review, I do review the municipal application as well as the state application, and make sure that all of the requirements in municipal code are addressed in their application forms, both of them. So I take the information from both and make sure that they've covered all of their bases. And then that's the report that you get on that checklist in the packets. And I know that planning does the same with their review, and they have the similar checklist for the land use and the Title 21 requirements. So there are a few things that the city doesn't have access to, and we just take that the state has done them and we'll review them, such as the fingerprinting. We can't do the federal background checks like the state can. So we take that portion of their review and just accept that they've verified that and would let us know if anything came back.
Okay, thank you. So I don't know which member might have submitted this question. So if anybody wants to pipe it up and talk about where they think some of the problems are with this, or if there's something we really could do with this in terms of our code.
Yeah, I think this one actually came
Go
from me.
ahead.
So if I could speak for a moment. And I think we did, we went through this at a previous meeting, and then I guess I was okay with where we landed. But, you know, we had in particular, it came out with the application. I think it was Ace down south end of Spenard Road in that strip mall, and the owner had a violation for selling or some drug violation in Nome or something like that. And someone from the Spenard community had gone through Courtview and had pulled that person's record. And there was another one that was similar, and she had done the same thing. And it was enlightening. I think in those things we deemed that they were outside of the limit as far as number of years that were relevant for the licensing and so on. But so anyway, I think we'd moved on from this one, and so I don't know that we need it.
If I may.
Okay.
Uh,
Yeah. Go.
So I think that since you mentioned the was it ICE? I forget the name of the business out in Spenard. That's one thing that we could do in our code is the state law, and when we addressed that, I had an opinion about that, and that gentleman's conviction, it was suspended imposition of sentence, and under the state law, since he completed the requirements for it, it was just a fact it was there, and they didn't have, I think, language saying that SIS would not be considered in these licensing factors, but we could include that we do consider SIS convictions when looking at marijuana license, so that's the choice thing. SIS convictions should be considered or should not be considered. And that's just a question, I think, for the licensing authority, if that makes sense. Anyway, that's a little more specific than this issue we were looking at.
Okay. Thank you, Mr. Gates. Ryan Yell, we have you in the queue.
Yes, thank you, Madam Chair. I just wanted to confirm Mandy was 100% correct when she said planning checks for, we have our own checklist and we do review the AMCO application, but we're just reviewing the AMCO application for concurrence with the municipal application and any potential non-compliance issues with municipal code that we can see. So that's just part of the special land use permit review. And then separately, I believe the situation that we're discussing with the gentleman's record and charges was Top Shelf Herbs of Alaska. Since we did mention a business name, I do just want to clarify. I believe that was Top Shelf Herbs and that was not Alaska Cannabis Exchange. So thank you.
Great, thank you, Ryan. Mr. Gates has a follow-up. Dean, go ahead.
I was just going to mention that if this issue of being able to verify truthfulness and maybe and Randy's correct that we don't have authority to do background checks, criminal background checks. The state does that, but actually APD is able to, the police, but we don't have that authority in relation to these licensing applications and our code enforcement officers. But that is something that could be added to our legislative program if it was desired to have a state law statute change allowing certain code enforcement, municipal code enforcement officers to have access to the background check system. So just putting out that thought, since we have legislative program suggestions on every agenda, this could be one of them if the committee wanted to add it.
Okay, great. Thank you, Dean. Yeah, we'll have to keep that one in mind then for legislative priority. Okay, so next on the list is actually, I know that's Mr. Weddleton's about the walls that go from the roof from the ceiling all the way to the roof for security purposes. So we'll add that to our potential Title 21 AO, which we don't have just yet, but we can kind of at least assign it to that, to drafting that AO. Unless you had any other comments on that, Mr. Weddleton.
No, I think that's good. And Dean, we worked out at the last, not too long ago, there was an application that was in a strip mall and we had an amendment that passed. And I think the wording in that is the same as we had in 2 other applications, or that we amended to as a condition.
Right.
Yes, exactly. And that last one we did rather quickly, and it was easy because we already had language from the prior applications, and I think that language could be added into Title 21. And I guess I need to give credit to Mr. Yali. I think he originally authored our language addressing this issue. Thank you. Mm-hmm.
Okay, great. Then we'll move on to the next one. And I don't necessarily understand what this particular one is getting at. So if anybody wants to elaborate on it that has more detail, that'd be great. But the question is, can a protected use sign a release from the separation requirement? Does anybody want to?
Yeah, I could speak to, I think
Great.
Chris put that on there actually, though. Is Mr. Constant here?
I don't believe so.
So I
He
think
emailed me that he can't make it today.
Okay, so I think this is in reference to, we had a case a couple years ago, I think. I don't think the license ever came to us, but we had some folks that approached me and Chris, I think some others, where there was a church and a marijuana retail shop wanted to go in, or some facility wanted to go in within the 500 feet from it, but the church didn't mind or care, and they were like, yeah, we're fine with that. But the way our law is written, it's not. So if you were a protected use who have ostensibly this right to be protected, but you don't want to be, there's no way for us to waive the requirement. So that is what it is.
Okay, and so that sounds like that could go. Yeah, I guess that would be a Title 21.
If I may.
Go ahead.
Of course,
Mr.
there's
Gates.
state law requirements too. So, but I think we acknowledge that.
Okay, Dean, did you want to comment?
I was also going to mention that there's some state law separation distances that we cannot toy with or waive, but those are very few protected uses in the state law, 304. Anyway, and I think that this might be a potential legal issue that we should maybe get the Department of Law's opinion on, because well, having just the current, I guess, protected user waive protection a requirement in code that might affect future operators of that protected use. That may not be, I guess, I'm not sure. There may be some legal issue with doing that, so we should check into it. we also have this issue when those, I think a 500 separation distance to Identity Inc. for a proposed marijuana retail establishment in the downtown area. And they were just under the 500-foot separation distance and wanted to waive. So in some circumstances it makes sense, in some it wouldn't. Like, anyway.
Yeah, so I mean, my pitch for at least exploring this is, I think, twofold. One, I think we can craft it in such a way that it doesn't violate some of the state laws, or it can be in place for such time as the state law changes. Actually, I guess there's 3 points. The second is, and I agree with Dean that it should be evaluated by the Department of Law, but I think that this is not uncommon in contract law, right? Where you can create an encumbrance on a property that then travels with the property to the next user. And for me, it's a sort of libertarian issue. It's a right of private contract. I've always been a little miffed that there is a private right to deny another user another legal private right near them. I'm fine with schools and things like that are public uses, but the idea that someone could put in certain kinds of private businesses or a church, which is a private entity, and thus deny some other private user the right to use property in the nearby area has always bothered me. And this is one way to potentially alleviate that, where those parties could meet and, they could either agree to waive it, or they could even, a marijuana retail establishment could go to a protected use and say, we will pay you X amount of money so that you will create this encumbrance on your property and you will give us the right to use this space. And I think that we should do what we can to permit that kind of private contract right.
Okay, fair enough. So, okay. But again, that's going to basically go through Title 21. So we can revisit that maybe when we get that draft going and figure out how to do the language with that. So anyway, we'll leave that one at this point. But thanks for the clarification. So we kind of get an idea of what that's all about. Then moving on, Jeff Hickman suggested that we have our code more closely match that of the states, and he got his wish. We're underway. So anyway, this is an interesting one. So
if I may.
Oh, yeah, comment. Okay, go ahead.
I think Jeff Hickman was referring also to some Title 16 provisions related to secondhand smoking. So we should ask him for a little specifics. I think he's getting his wish with all of the Title 10 for sure.
Yes. Okay. Well, then
If I
maybe
could jump in.
Okay. Is that John? Or is that...
Yeah, we did get from Mr. Hickman at our, I think, January 9th meeting, a comparison of, he did, maybe it was the next meeting, but he gave us a comparison of state law and, sorry, I'm flipping through briefly here, but yeah, he did. It was at our January 23rd meeting. Yes, go ahead, Dean.
Yeah, I remember now, Mr. Weddleton, he had that list, and I remember thinking that, oh, well, yes, it would be important for the changes he recommended, but they were more general about smoking, and I wasn't sure that they would fit in with this ordinance. But I would take a look at this list again, and maybe it would be a separate ordinance, maybe parts we can include in this one. But I think they weren't really specific to marijuana licensing so much as they were to smoking issues.
Yeah, that agrees with my notes. I have a note on here that we said we should send it to the health committee and also wait until after the vote on on-site consumption. So I think that was a good idea on January 23rd and to do that now.
Okay, and Mandy just sent that list, and it is on the website as well, on the committee's website. But Mandy just put it up on the chat page. And now I've lost my document. Okay.
Huh.
All right. So, yeah, we will continue on with that. And where did you? Sorry, John. Where did you leave your last thought on that one?
Well, I think on that, the thing for Jeff Hickman and the stuff, send that list to the health committee,
Okay.
because the health committees did a lot of work on, the secondhand smoke or whatever, those laws and or the age limits on smoking and so on,
Okay.
tobacco. And I think they're still working on more. I think there's still proposal tax vaping and so on. So I don't know. So who would send that? Mandy, would you send that to Suzanne and Austin, or Austin, are you here?
Yeah, Austin's on with us.
Yeah, I'm here. I haven't
All right,
seen that
Tad, you're good.
document, so I'm just sort of following what you all are saying, and sounds reasonable. I think Suzanne and Chris are working on the tobacco taxation issue, but yeah, if you want to send over anything, we can evaluate how it fits in with the HPC.
Okay, good.
Okay. Yeah, Dean, go ahead. You have something else?
If I'm, I had been on hold by Teams for some reason, but I just caught the end of this part about the taxation issue with our ordinance. Was that about the ordinance to tax vaping and electronic cigarette products? And if so, I had communications with Natasha Pineda, and we don't think the health department will really have any involvement in that ordinance. It's a treasury issue and treasury administration.
Okay, thank you, Dean, for the clarification on that. Okay, so boy, we're trying to get through our list here.
Should I
Can we?
put it back up on screen?
Yeah, I'm not actually watching the screen. I'm watching it on my own, but if people want it up there, that might be better. Great, thank you. So can we renew a license for less than a year? And it looks like you had an answer to that, Dean, about that we can set a different date, but it gets a little convoluted, gets a little more complicated. I'm not sure who actually asked that question and why, and is that something, I mean, that this would fall under chapter 10 or title 10. So is that something that people want to pursue in some way? And let's see. So I'm not sure who asked that question, but Dean, you had a comment about the idea of renewing a license for less than a year. Do we want to do that? Is that something you would end, or yeah, thoughts on that?
I think it's something that you could do if there's an individual licensee who's, a problem operator, has a lot of NOVs, and you want to them to come back in a shorter time frame. But I think should work with the clerk's office on doing that, because that puts some additional workload on the clerk's office to monitor when you put a shorter renewal period on just one licensee. But if you wanted it for a category, that's a bigger code change. But you already have authority to do this case by case, I guess. And my notes here, I'm sorry if it sounded convoluted, was just that if you see a problem licensee and say, we're just going to renew for 4 months, come back in January 1, or renew by January 1. But if you do that, you don't want to forget to say your renewal applications due December 1 or 30 days prior, because I think that's often an oversight when setting the deadlines, to also set the deadline for the process itself. For them.
Okay, Thank you, Dean.
Can
Yeah,
I
it
jump
seems
in?
to me, yeah, I was just gonna say, it seems to me that we somewhat deal with this just by having automatic periodic reviews on some of these licenses that we have questions about or concerns on. And so we might actually be handling it in a different way. So I guess my question would be, is this actually worth pursuing? But John, you've obviously got some thoughts, so go ahead.
Yeah, I mean, we could just rely on, if we had an operator, we wanted to make it shorter, we just have an amendment and say, on the conditions you come back in 4 months. And if we remember, say, so we want the application in 3 months, or Dean, if maybe a code change could be in there that says, it just is standard wording that all renewal applications have to be 30 days or whatever, maybe Ryan can chime in, but 30 days before, or Mandy, 30 days before the renewal date or something. So if that's already in code, if we forget to add that to the amendment, it's already stated in there somewhere.
That's a good suggestion. I'll include that. I'm making a note here.
Okay, so we can continue to follow up and pursue this one a little bit then. Okay, so just for purposes of moving on and maybe getting through we're not going to get through our list. Next thing on the list is who verifies that the applicant has no NOVs and has no felonies. We kind of went over this a little bit already, so I don't know if there's anything else to actually add to this particular concern. Any comments from the committee on this one, or even from Mandy? I think we got
that came
we got
from
the
me.
story.
And
Okay, so we're okay with that one, John?
I would add one thing here. The last question is a look at court review adequate, and the answer is no. I don't think so. And you don't want to rely on court review and what's listed there. That's
Okay,
helpful for a starting point.
okay, that's good to know. Thank you. So don't trust it, huh? Okay, then Meg had another one. When there's an informal land use determination. Okay, so I think we're looking at land use. So we're talking Title 21. So we should probably just designate that one as a Title 21 issue. And for purposes of today, we'll move on. So.
well, actually, could I jump in on that? I think.
Oh, sure, absolutely.
I think there is wording. It's not in this document, but Dean or someone had worked up some wording that I have on my screen in front of me. Maybe it isn't here in this document, but there is.
Yeah, it's right here.
Am I missing it?
I think this is it. The first page.
Yeah, there you go.
Are you pulling it up? Oh, good.
Is Meg here? Is this different?
Yeah.
Sorry, guys. I'm popping in and out. It's the first day of school. So that was, that was
right.
close.
Well, I knew I'd seen it before, just minutes ago.
Okay, so they're connected. All righty. All right, and it looks like there's some other examples of some of the other jurisdictions doing what they do in other places. So can we skip through that then? And is that makes it the end of the list then? Correct? Am I seeing this right?
That
Okay.
does. We had a few other items that I have in a note that came
That are
up
not on this list?
since.
Okay.
Yeah, it was since this document, and I didn't. I don't have crystal clear notes on where they came from or why, but can I go through those briefly?
Yeah, please. Yeah, absolutely. Yeah, let's get through this. Good.
Okay. So I don't know if this is all inclusive. But just some I had typed in, and one is to clarify what's the process when a licensee closes. And I think we had one business that closed. And we go, oh shoot, what do we do? And just and I think code enforcement, we must have discussed this somewhat. Code enforcement says, well, here's what we do. But I'd be more comfortable if there were a little bit of a list. We would do X, Y, and Z. And I think we saw the state goes in, takes the plans, but I'd like to see that made clear. And then another one is addressing significant management changes. We have, changes in ownership addressed, but we saw recently when, GNC was taking over RC Tinderbox. I guess they bought it. They changed the whole board or something, but I didn't. Just a brief note here that seemed like it was a vague area for us.
Yes, that's a
And
good.
Oh,
then,
I'm not sure I understand that one.
I'm not sure I do either. I'm just reading notes that I typed in at some point. I think they just came up during a meeting and I punched them in. But we have, we see changes in ownership. Great Northern Cannabis, a couple of things happened, but in that big issue, they completely changed their board. They got rid of their management, and I guess their management changed. Their board completely changed the management. And we don't really see that. That was pretty profound difference. They got rid of certain people and put new people in. And that's almost more of a change than, to me, it's almost equivalent to a change in ownership of a business. Who's running this thing? And we don't really have a way of notification of that. It's like, if the board changes more than 75%, please let us know, something like that. Or if the directors or the management or something, and maybe that's digging too deep, but in that case, that was a very profound change.
Okay, so that's something we ought to get some language in there in a draft form to add to our AO. And before we move on, I need to let Mr. Dunbar in here, if I could, real quick, just to make sure we're not missing the point that he wants to get to. And I promise, Forrest, I'm not ignoring you. I just now saw all your queue requests. So do you want to jump in here now, Forrest?
Yeah, that's just one queue request. I wasn't actually urgent. I was just joking about the fact that I can't spell queue. So, and I apologize. I think all of us are kind of multitasking right now, except maybe you, Crystal, and John. So if you already addressed this, I apologize, but we had previously talked about the issue that arose during the Downtown Hope Center Alaska Sense issue, kerfuffle, that involved the fact that our sort of variance standards were impossible to meet because you had to verify that there would never be any negative impact, basically. I don't know if Mr. Yell could speak to that. I remember he was working on that issue, and we talked about trying to revise that language so it would be sort of more based in reality as opposed to impossible hypotheticals.
Yeah, thank you, Madam Chair and Assemblyman Dunbar. So that variance standard, I think we could tweak a little bit. Instead of saying no adverse impact, say, minimize it to the greatest extent possible, something along those lines. But another point I do want to make is that if the Assembly is having trouble finding that a particular variance standard is not met, I do think that that's kind of a red flag that maybe that variance shouldn't be granted. I do want to throw that out there. So.
Yeah, I certainly agree with that. The notion that variance standards should have a high bar, but I think that the language we have in there now is basically an impossible bar. And I think correct me if I'm wrong, but I think we granted that variance because we found that it wasn't necessary because they weren't a protected use. Isn't that correct, or am I misremembering?
So that variance request became unnecessary. So it was removed from the actual request. So they just approved the special land use permit because the separation distance requirements were met.
Okay. Yeah, that's how I remember it too. So that to be added to the sort of list of things we want to examine and perhaps revise the legal language for.
Okay, so this is a good Title 21 topic, but I think we've got Dean
Yep.
wanting to cue in here, and I've got Meg. So Dean, did you want to comment? And then I'll go to Meg.
No, never mind.
Okay, thanks. All right. Mrs. Olatel.
Thank you. And thanks to Mr. Dunbar for remembering this issue, because I think we do need to clarify the code to what planning would like us like to get at about this. I don't know that it's no adverse impact, but there's got to be different language, because I agree it was almost an impossible standard because you can't prove the negative, especially prior to operations. And if I remember correctly, we had a license where a variance was actually recommended by planning and zoning. And I believe it was because the actual lot separation made great sense. But if we can somehow encapsulate why that was okay into more generalized language, or look at those where they have been granted, I think that would be much more realistic and much more reflect the intent of when a variance should be or is more likely to be allowed. Because I think the current language is really there should be no variances granted under the current language, but there are. So I think this is an important piece that we shouldn't let slip by.
Great. Yes, I appreciate that. And I think, I'm writing down all these notes here too, that I think this goes on our Title 21 list, and we can go through that whole list a little more thoroughly. But since we have the AO right now on Title 10, I want to make sure we get those things down so that Dean knows kind of what the thoughts are and can really start drafting more of the specifics. So the other thing I want to do is I want to go back to Mr. Weddleton, because I think I kind of cut him off on the end of his thoughts about the significant management changes. So I want to kind of give that back to John to finish those comments, and Dean might have had some comments on that as well. But do you want to wrap that up, John?
Yeah, I guess I ended with sort of muddled thoughts, and that's where I am on that. I just,
Okay.
we, if there's a change in ownership that could be fairly small, we have gotten, I think it mostly goes to Mandy, but at a certain level, it comes to us. And here we have this profound change in how this business was operated, and there was no trigger for it to come to us to double check. So I'm not quite sure where to go with that. It was just, seemed like an odd thing. So does Dean
Okay.
have thoughts on that, or Mandy?
Yeah.
Madam Chair, could I ask something?
Yes, please go ahead, Mr. Gates. Yes.
If I could bring up my screen. So we already have language about ownership changes, and it already requires, I think, that I'm sorry, I'm looking for the language. It's the controlling interest, and what it means. So I guess if Mr. Weddle can identify where on these that it needs to be tweaked, that would be helpful. This is the section we would look at, and I'm not sure if this is inadequate or what.
Well, I
You
think
know,
you were
it's
getting something different. You were really getting at something different than ownership. You were getting at management, right, John?
yeah, and maybe that's just something we just butt out of and let them do their thing. That's essentially where we landed, but it was just so significant, but significant because of the issue that led to people getting fired. But so we only look at ownership. So I guess I need to think about this some more. But anyway, everybody, maybe smarter minds can deal with it, twist it around
Okay.
a bit.
Well, I think we got Pete Peterson that
We could
has
probably
a
talk about this more offline.
Sure.
good. Okay, thanks. So Pete, got you up next.
Okay, thank you, Madam Chair. And I was just going to say on the subject of weighing in on the change in management, I don't know, I think that's getting into the weeds a little deep, micromanaging maybe a little too much. Change in ownership makes perfect sense for us to take a look at that. But, we have a number of these marijuana businesses. And if we start reviewing change in management, I just think we're taking on too much more than we have time for. And I think just staying with reviewing a significant change in ownership is, I guess, more reasonable in my opinion. Thanks.
Yeah, thanks, Pete. So, well, I'd like to, oh, Mandy, go ahead.
I just wanted to comment on the transfers. So the Assembly does review the transfers of controlling interest or transfer of the license currently, and they have to be the ones to approve those for the municipal license and then give recommendation on the state license transfers. You also review any, they're called reports of change of ownership, so they're the non-controlling interest changes. Any of those will show up with their renewals annually. There's kind of a section that requires any change from their original license that you saw previously. Anything changes that weren't approved by the Assembly should be included with the renewal. So you do get to review those. They're just not something that the Assembly has to vote on.
Okay, great. Thank you. Okay. Well, I'd like to wrap this up then and leave.
I got one more.
Okay.
Sorry. Okay. Let me grab this. And again, this was from our list. One was the thought, should we reconsider on-site consumption of edibles? And again, I'm not sure where this one came from, but we had the big failure of the on-site smoking.
Right. Yeah, that was that came from the, from one of the community councils, and I heard it, I had somebody call me and I can't remember now who it was either. But anyway, that was definitely something to consider.
Okay.
And I think
how and when?
The rationale behind it was that nobody had applied for a license for that. So it's kind of like, what was the point of having it in code if it really, there's no need and nobody's going to take advantage of it. Okay, let's see. Yes, and Ryan just put in the queue that there's been no applications for on-site consumption endorsements received to date. So.
Well, I asked Dean to, I guess we should discuss this. Should we go ahead as part of this change in the licensing is remove that, make removal of that part of this AO?
I vote no. I don't want to refight that stuff.
Well, I would say it's worth asking the question. I mean, if the industry just says, yeah, we're never going to do this, then yeah, that's kind of pointless to have it in there. But I mean, I don't have a problem with having it in there to actually ask the question and then have the conversation. But that's my thought. Meg.
I have to agree with Forrest. I think we've done the work. We leave it in there. We give it some time. I don't think we've had a considerable amount of time since it's been in there, especially during any kind of non-COVID times. So I would rather just hold, maybe calendar it out, for a couple of years from now, but then not go back and redo the work we've already done.
Yeah, that's a good point too. You'd be crazy to open on-site consumption this summer, or.
Right. And typically, I mean, we just did that last year, and typically you give something 2 years before you try to do anything different with it. So maybe next year is the better timing. And I see Pete's comment that says he agrees. So with Forrest on that issue. So okay.
And I can live.
Anything else, John, or pardon?
No, that was all I had on notes. That's stuff that had popped up.
Okay, great, thanks. We just have a couple minutes left, so and I see Austin also chimed in, and she agrees with Meg and Forrest and Pete. So So anyway, with the last few minutes we have, I just want to make sure that members don't have some kind of comment or something else to bring up. And if not, we'll see if there's anybody that wants to comment in the audience participation portion of our meeting. So Assembly members' comments?
Yeah,
All
just to
right.
clarify, just to clarify, we have kind of mocked up the licensing change document, and I think we've agreed to add some stuff to that. But I would also like to see a start on the Title 21 AO draft as well.
Yeah, and I think Dean said that he would be starting that process as well. And since we identified some on our list that actually go in that particular pocket, then I think we started. Dean, do you want to comment on any of that in terms of how you might be being prepared to move forward with an AO for the Title 21 portion?
Yes, I just have one comment that I will connect with Mr. Yali after this meeting and talk to him about it, and he would probably be drafting it. Sorry,
Okay.
but we will coordinate something.
Okay, great. Well, we actually made some pretty good progress getting through this list today. So good job, everybody. Have a minute left. Is there anybody that wants to comment from the public? And Mandy, you might have to help with that in terms of seeing who's on and who might want to be participating. And I guess I will say then, if somebody does want to comment, if you're calling in on the phone, you have to hit *6 on your phone in order to be unmuted. So I'm sure the silence is killing all of us. So if there's no comments, then somebody can make a motion to adjourn and we'll be done. So
Move to adjourn.
all right.
Second.
Thanks, Pete. Thanks, seconders. All right. Thanks, everybody.
Thanks, Crystal.
Bye.